This AZCourtHelp Legal Talk is on Family Court 101.
Hello, thank you for joining us today. My name is Gretchen, and I'm the law librarian in Coconino County. The information we're going to talk about today applies statewide, and today we're going to go over the basic steps in a divorce, legal separation, or custody case. Let's first take a look at what has to be true to start one of these case types in Arizona. If you're filing for divorce, you or your spouse have to have lived in Arizona for the 90 days leading up to your case start date. If you're filing for legal separation, the 90 days doesn't apply, just you or your spouse has to live in Arizona on the day that you start the court case. And if you have kids in your case, your kids have to have lived in Arizona for the 6 months leading up to that case start date. Assuming that's true for you, your first step to starting this process is to get your self-help packet. This is going to be forms and instructions from your county. So usually you're going to file this case in the county where you live. You can get the self-help packet from your county, from your law library or your court, or from this website, AZCourtHelp.org. Once you get that packet, you might be tempted to jump right in and start filling it out and start moving forward. But we do recommend with this kind of complicated process that you set aside the time to read the instructions before getting started on those forms. The instructions are going to walk you step by step through what you need to know to fill out the forms, decisions you need to make in order to fill them out correctly, and what you need to know about how to fill them out, what to do with them after you fill them out. So if you read the instructions, you're going to have a smoother process because you're going to make fewer mistakes. You're going to know what you're doing. It's a good idea to read those before starting filling out the forms. Once you have read the instructions, you're ready to start filling out those forms. And here's an example of what that might look like. Look a little different if you're filing a different case type or if you're in a different county, but the idea is the same. It's just going to prompt you for the information that the judge needs to process your case. Let's take a look at a couple parts on this form. Here in the upper left-hand corner, it's asking for the name and contact information of the person filing this form. You're going to see that at the top of anything you file, or at the top of anything the other party files in this case, and that's because there's two of you, and the judge needs to know right away at the top of the form which party filed this form that I'm looking at. And then this section is asking for the names of the petitioner, that's the person who's starting the case, and the respondent, that's going to be the other party. This isn't saying who is filing this form, it's just identifying which case is this. This is Jane Doe as the petitioner and John Doe as the respondent, for example, but maybe John is filing this form. And whoever is the petitioner on day one of the case is always going to be called the petitioner forever in this case. So if Jane starts the case on day one, and then say 2 years later, John wants to change child support. When John files to change child support, he is still going to list himself as the respondent, and Jane is still going to be listed as the petitioner. Let's take a look at some words and ideas that you're going to encounter as you go through your forms that you might not be familiar with. If you are filing for divorce, there will be a statement on your form that says something like, "Our marriage is irretrievably broken." Irretrievably broken means that there is no chance that you're going to reconcile. And this is the one and only thing that has to be true in Arizona in order to get a divorce. You don't have to prove that anybody did anything wrong, had an affair. None of that is relevant in Arizona to whether you can get divorced. All that has to be true is the marriage is irretrievably broken. If you're filing for divorce or legal separation, the forms are going to ask you to list your property and your debts, and to tell the court for each piece of property, for each debt, who should acquire that at the end of the divorce, who should be solely responsible for that or solely own that at the end of the divorce. And the form is going to divide property and debt into two categories: community property and debt and separate property and debt. People sometimes have the wrong idea that what community versus separate about is whose name is it in. That is not what it's about. Community versus separate is actually talking about when did you get it? So, in general, any property or debt that either of you acquire during the marriage is considered community property, even if only one person's name is on it, even if the other person doesn't even know it exists. That is by law typically community property or debt if you got it while you were married. And then you can probably guess what separate property or debt is. That, in general, is property or debt that either one of you had before you got married. If you have kids in your case, you might wonder, why am I not seeing the word custody anywhere in these packets? Custody is one of the main things I want to talk to the court about. Well, you'll still be talking to the court about it, and it will still be one of the main things in the packet if you have kids. It's just that Arizona law doesn't use this word, custody, anymore. So the forms are going to use the new words. So now in Arizona, custody is a combination of two ideas. One, who's going to make the decisions about the kids? And this is called legal decision making authority. The other part is where are the kids going to live? So those are the terms you're going to see on the forms, but put together, they make up what we think of as custody. Let's take a look at each of those. Legal decision making, like I said, is the parent's authority to make decisions about the kids, decisions about religion, education, healthcare, etc. And you'll be telling the court on the forms whether you want you and the other parent to share joint legal decision making, or if you're wanting one parent to have the sole legal decision making authority. So it's going to be joint legal decision making or sole legal decision making. And then the other part of custody is where the kid's going to live. They're either going to be living mostly with you, mostly with the other parent, or about equally with both of you. And then on the forms, you'll be detailing what will the visitation schedule be and all the details of that. Where will the pickups and drop-offs happen and when? Which days of the week will the kids be at each household, for example? What holidays will they be at each household? So those things make up what we think of as custody. Also, if you have kids in your case, you'll be addressing child support in your forms. Child support is based on a calculation that's written into the law, and it takes into account your income, the other parent's income, and a bunch of other dollar amounts. It does a calculation on that, and it says, here is how much per month this parent should pay to this other parent. So you will need to present that calculation to the court, but what if you don't want what that shows as the outcome? What if it says that parent A is supposed to pay $400 a month to parent B, but actually you don't want any child support. You want it to be zero, or you think it should be higher, for example. Anything different from the calculation, you can make that request of the judge to do something different, and that is called asking for a deviation from that calculator. If you decide to ask for this, just look on your forms for the section on deviation. It'll use that word, deviation, and it'll prompt you for the additional information you need to provide to request that. The judge is only allowed to agree to a deviation if the judge believes that that will be in the child's best interest. Now you have completed all of your forms and you are ready to submit them to the court in order to get your case started. When you give them to the clerk of superior court in the county where you live, some of the forms will need to have been signed in front of a notary. You'll need to have a certain number of copies, and you're going to need to know how much is the filing fee in your county and what form of payment does your county accept. So these three things can vary a little bit from county to county, how many sets of copies they require. Do they accept personal checks? For example, in Coconino, we do not accept personal checks. So it's a good idea to make sure you know these details before you go to the court or before you mail your paperwork to the court to save yourself the hassle of, for example, submitting a personal check and getting it mailed back to you, or having to go find parking again because now you got to go to the bank and get a money order. And all those details will be in your self-help materials. If you need help with the filing fee, you can request that of the court, and your court will have forms to ask for that help. That help is going to range from a complete waiver of the fee in very limited circumstances. More likely, it would be a payment plan or a delayed start date on the payments. Once you have filed your papers with the court, you have to give a copy of them to the other party. This is called serving the papers on the other party. The court needs to see that the other party has seen what you have filed and had an opportunity to read it, think about it, and consider if they wanted to file any objections. The judge is required to give the other party this opportunity to participate in the case before making decisions about the things that you asked for. You have to serve the other party in a certain way, and you have a couple options as to how to do that. The first option pictured here is a sheriff or a process server in the county where the other person lives, hand delivering the copies to the other party. If the other party lives on tribal lands and you would like to use this option, then you would be using tribal law enforcement or a tribally licensed process server. Your second option for serving the other person is a free and easy way to serve. If the other person is willing to sign a form in front of a notary called the acceptance of service form. And this form basically just says, I got a copy. It's probably going to be longer than that, but it boils down to, I got a copy. It doesn't say I agree or I disagree, just acknowledges that they received that copy. So if they're willing to sign that in front of a notary, this is a free and easy way to get them served. And your third and final option for serving someone, if you know where they are, is to mail the copy to them using a special kind of mailing called certified mail. With certified mail, the post office will attach this green card pictured here to the mailing, and the other person will have to sign to receive the mailing. And after that happens, the post office will return this green card to you with that signature on it, and that's your proof that they have received it. If you use this option, be aware that there's more than one kind of certified mail, and only one kind is going to work for serving the papers that we're talking about today. And that is called restricted delivery, certified mail with restricted delivery. Restricted delivery means only the person I have addressed this to can be the person who signs for it. If you don't ask for restricted delivery and the other person's not home, but their mother is home, the post office will let their mom sign for it. And then you will not have successfully served because it has to be the person who signs for it. So just make sure to ask for restricted delivery. And all these details I'm talking about service are also going to be in your self-help material. So you'll be prompted about this restricted delivery as you get to the instructions on service as well. And one last thing about certified mail is that this is not a service option if the other party lives on tribal lands. So those are all the ways to serve if you know where they are. If you don't know where they are, you're going to have to publish a notice in a newspaper, and that is your way of legally serving them. What exactly do you need to publish? How many times does it have to be published? How do you determine what newspaper to use? All of those details are going to be in your self-help instructions that will guide you on all of that. And finally, on service. If the other person is not in the United States, you are probably going to have to see an attorney to learn how to do this one part of your case. How do I serve somebody in Argentina? How do I serve somebody in Guatemala? How do I serve somebody in Japan? We just looked at those very specific options for how to serve somebody in the US. There's also going to be very specific options for how to serve somebody in every other country, and it's going to depend on the country they're in. So unfortunately, there's not a self-help resource to figure this part out if this is your scenario, and you will probably need to see an attorney to find out what your official service options are for whatever the country is where the other person lives. Once you have served the forms, you need to let the court know that that happened, because like we said, the whole point of service is so that the court knows that the other person has gotten what you filed, has had an opportunity to review it, and has an opportunity to let the court know if they object to anything. So the way you let the court know that you did that is if you used a process server or sheriff, that individual will usually create their own form called an affidavit that says how and when they gave the forms to the other party. And the process server or sheriff will often just file that into your case for you, but just keep an eye on making sure that that gets filed. If the other party was willing to sign that acceptance of service form saying, yeah, I got these forms, you're just going to file that acceptance of service form with their signature on it with the court. If you served the other person through certified mail, you're going to file that green card with their signature on it with the court. And if you published in the newspaper, you'll be filing your own form that says, here are the dates that it was published, here's the newspaper that I used. And your self-help materials are going to have forms and instructions for all of these pieces as well. Now that you have served the other party, you're in a little bit of a waiting period because the court rules give them a period of time to have time to read over it, time to prepare an objection if they have one. And their deadline to file a written response if they want to object to something is 20 days from the day they were served if you served them in Arizona, or 30 days from the day they were served if you served them outside of Arizona. And those days do include weekends and holidays. While we're in this waiting period, let's take a look at this requirement that applies to any case in the types of cases we're talking about today that involve kids. If you have kids in your case, Arizona state law requires you and the other party to take a parent education class. And the idea of this class is to give you and the other parent ideas and information on how to make this time of change in your family as easy as possible on your kids. Each county provides this class in a slightly different way, but your court will let you know either in your self-help information, or you might receive this information in the mail after you start your case. How do you register for and take this parent education class? Okay, so our 20 or our 30 days have now expired, and depending on what the other person did in that time period, your case can go in one of three directions. Number one, maybe you have come to agree on everything. If you do, you can file a form together called a consent decree. This lists all your agreements. It has both your signatures on it. Once you file a consent decree, that's typically the last step that either of you has to take in the case. Once that's been filed, it's just waiting for the judge to review it and sign off on it. When the judge signs off on it, that finalizes your case. It says you're divorced, or it says here's what the custody is. It's the final court order. And you can file this consent decree at any point in your case where you come to an agreement. So if you agree from day one, you can file it on day one. And you might see that referred to, when you file it on day one, you might see that referred to as a summary consent decree. This is where you file everything, all the papers all at once, including the consent decree. It has both your signatures on it. When you do this, you actually enjoy a slight reduction in your overall filing fee when you file this at the very beginning, and you don't have to serve the other person. That all applies to the situation where on day one, you agree and you file the consent decree together. Cost less, no service, fewer steps. Now, maybe you don't agree on day one, and what you file on day one does not have the other party's signature on it. You file, you serve. Over the next month, you have some conversations, and you come to a complete agreement. At any point in your case where that happens, you can together file a consent decree, and again, that would be your last step. You're just waiting for the judge to sign off on that. If you file the consent decree not on day one, but a little bit later in the case, there will be a filing fee for the other party to participate in the case by signing that form, and the other party would be eligible for the help with the filing fee that we talked about earlier. Okay, so that's the first of three things that could happen after you serve the other person. Number two is that the 20 or 30 days go by, and for whatever reason, they have not filed anything with the court. The court, as far as the court knows, the court doesn't know why we haven't heard from them. Do they agree? Do they disagree? Do they not want to participate? For whatever the reason, they haven't filed something. If this happens, you can finish up the case without their participation or input by filing a form called default. And default basically says to the judge, hey, I filed, I served, those days went by, they haven't filed anything, let's wrap this up without them. And with default, the judge will make the final decisions based just on what you filed at the beginning of the case. Usually with default, there is no court date required. The one exception to that is if you served the other person by publishing a notice in a newspaper, you will have a hearing to finish up your default case. And that hearing might be by Zoom or phone, or it might be in person, but if you did not have to use the newspaper, then usually once you file for default, that's the last thing you have to do. And you're in that situation again where you're just waiting for the judge to review everything and sign off on the final paperwork. And you probably can guess what option 3 is, which is that they do file something within the 20 or 30 days. They're going to do that if they disagree with any part of what you have filed and they want to let the court know that. And what they would file is called a response. So if they do file a response form with the court, then a few additional steps apply to your case at that point. And the first new step is called disclosure. Once a response is filed, both you and the other party have to do this process called disclosure. It's got a couple parts to it. And one part is that you're going to be required to exchange certain information with each other that relates to the case. It's going to be a specific list of information that's written into the court rules. There'll be self-help information on disclosure, and it will tell you exactly what you need to give each other. For example, if child support is an issue in your case, you might need to exchange W-2s. The other part of disclosure is that you're going to be required to meet and try to come to agreements. This could be over the phone, doesn't have to be in person. And then at the end of that process, you're going to need to file a form telling the judge, we've completed disclosure and here's where we're at now on the issues in this case. If through this process you come to a complete agreement, then you can file a consent decree and just wait for the judge to sign off on that. But maybe you have not. Maybe there's still parts you disagree on. So you'll be continuing forward then through the steps at this point. So that's disclosure. That's one thing that you'll have to do if a response is filed. Another thing that might happen if a response is filed is the judge might schedule a meeting with you and the other party. It might be called a resolution management conference or a case management conference. Probably it'll have the word conference in the title of the meeting. And if this does get scheduled, you'll both be notified in the mail of the date and time of this conference and how to participate in it. And this is just an opportunity for the judge to sit down with the two of you, it might be over Zoom, and find out where are you guys at on the issues in this case. What do you agree on at this point? Where are your disagreements? And for the judge to determine what procedurally needs to happen next for us to move this case forward. Another thing that might happen when a response is filed is maybe you and the other party will take advantage of your court's mediation services. Mediation is where you and the other party sit down with this neutral third person. They're called the mediator, and their job is to try to help you come to agreements. Different counties have different types of mediation services. So you can check with your county court or your county law library to see what's available to you and what the details are. So, for example, what topics does the court offer mediation on? Do they offer mediation on child support? Do they offer it on how to divide your property and debts, or what topics? How much does it cost? Is it free? When can you ask for it? In some counties, there's some mediation available even before you file anything to help you work out agreements before you even file papers. And in some counties, you have to have filed to qualify for mediation. And then mediation services also are available in certain situations even after your divorce is finalized. If you run into a future custody conflict and you'd like some help from a mediator. So your court will have those details. Okay, so now that maybe you have gone through mediation, you have completed the disclosure process, you may have had a conference with the judge, it's time to stop and take stock of where you're at now and all the issues in the case. Have you come to a complete agreement? I know that you probably know that if you have at any point, you can file that consent decree. If there is still some part at this point that you disagree on, then your case is going to be wrapped up at a trial. And in some counties, when you get to this point in the process, to move it forward, one of you has to file a request for the judge to schedule the trial. And that form says, we've completed all the requirements. We've done disclosure. We still have a disagreement. We need a trial scheduled. There'll be a self-help form for that. But in some counties, the court is keeping track of the progress of your steps, and you don't need to file that. They just go ahead and schedule that trial. Your self-help materials for your location will prompt you if you do need to file this form. So if the court does schedule a trial, you and the other party will get a court order in the mail with the date and time of that trial. And this is the time to really set aside half an hour, make yourself a cup of tea, clear some space on your kitchen table, and give yourself some quiet space to read that carefully. Have your calendar out, have your yellow highlighter out, because it's probably going to tell you a series of things the judge is ordering you to do before that trial date. Probably the judge wants you to complete and file with the court multiple forms. Probably the judge is going to order you to exchange some additional information with the other party. And each of these requirements could have a different deadline. So on the face of it, it might look a little overwhelming when you get this court order scheduling the trial. But if you have your cup of tea and your yellow highlighter, and you've got the time and space to just read through that, highlight the deadlines, put them on your calendar, make sure you understand it all. Your law library will be able to connect you with self-help materials for any of the requirements in there. And if you have any questions about the requirements, you can contact your law library for help explaining what those requirements are asking you to do. What is going to happen at this trial? At the trial, you and the other party are going to come before the judge. This might be in person, might be virtual, and you will each have an opportunity to tell the judge your argument about why the judge should order what you're asking for. This is where the judge is going to be resolving the parts of the case that you're not able to agree on together. You'll also each have the opportunity to present any witnesses or evidence that you may have to support your arguments, and the judge typically will make the final decisions in the case at the trial. And so that is the end of your case. That would be the last step in your case. The last step in the case is either you're going to get the consent decree signed by the judge back in the mail saying your case is finished, or you're going to get the default decree back from the judge signed by the mail saying your case is finished, or the case will be finished at the trial. If you are filing for a divorce or a legal separation, it will take at least 60 days to get that final court order from the judge. And if this is a custody case for unmarried parents, that's going to take at least 30 days. It's state law says that in a divorce or legal separation, the judge is not allowed to finalize the case until 60 days have passed from the date of service. So let's look at what would that mean if you file a consent decree on day one? And what I said is you file that on day one together, and you don't even have to serve, it costs less, and that's the last thing you have to do. All that's true, but just be aware that while you don't have to do anything else, you're not going to hear back from the judge for at least 60 days because of that state law requirement that the judge has to wait that time period. I know I said from the date of service, and that if you file a consent decree on day one, you don't have to serve. So if you file the consent decree on day one, the judge has to wait 60 days from the day that was filed. Otherwise, the judge has to wait 60 days from the day the other party was served. I'm going to go over a review here of what we've talked about. So your steps in this process are, you're going to get your forms, fill them out, and file them with your court in your county. Serve them on the other person, either through process server or sheriff, certified mail, or maybe they'll sign the acceptance of service, or if you can't find them, you're going to publish a notice in a newspaper. If you come to agree on everything, you can file a consent decree together. If the other person does nothing within the 20 or 30-day deadline after being served, you can file for default. And that's usually the last thing you have to file, unless you publish in a newspaper, in which case you'll have a default hearing before the judge. And then if the other person does file a response, you're going to do disclosure. You'll maybe have a conference with the judge, maybe you'll have mediation, and if through all of that you come to a complete agreement, you'll file the consent decree, and if not, your case will end at a trial. And if you have kids in your case, you'll need to make sure to take that parent information class. That's usually going to be required before the judge will finalize your case.